Good morning. My name is Dwight Mitchell. That's spelled DWIGHTMITCHELL. Before I go further, I'd like to give a special thank to Senator Andrew Matthews from District 15, who joined us at our last press conference, but who cannot be here today. While he's not a party to our lawsuit, Senator Matthews had received numerous phone calls from his constituents regarding CPS. As he mentioned when he was here during the last press conference, this is something that we can no longer turn a blind eye to. And as a first-term member of the Senate, Senator Matthews stated that he feels legislation changes are needed. And again, I want to thank Senator Matthews for speaking out at our last press conference. Some of you are aware of my tragic experience with Dakota County Social Services. Just to briefly fill you in, my children were taken away from me and retained by CPS for 22 months because of fabricated evidence, false reports, and illegal practices. After I exposed this illegal activities to the court with written documentation, Dakota County hastily dismissed the case against me so that the judge could not rule in my favor on their illegal activities. There are approximately 85 pages of key official Dakota County documents attached to my federal civil rights complaint as evidence of their illegal activities. Out of this tragedy, a soldier was formed. I liken myself to a soldier for injustice and the less fortunate. I formed the association Stop CPS from Legally Kidnapping Children. I created a petition on change.org. I created a pro se CPS self-help webpage. I've spoken with numerous Minnesota legislatures, spoken for the governor's legislative task force on child protection, and filed this civil rights lawsuit with injunctions for my association and my family, all with the intent of making a lasting change in Minnesota's child protection system. While I knew Child Protection Services had issues, it wasn't until I filed my civil rights complaint that I became aware of the magnitude and the breadth. Our phones have not stopped ringing and our email inboxes are overflowing. Our association had 250 members 30 days ago. We have grown to approximately 1,265 in less than 30 days. Our petition, which only had 1,200 signatures 30 days ago, now has 4,279 as of this morning. All of this overwhelming response and cries for help in less than 30 days from 23 distinct districts across the state of Minnesota forced us to pause and completely rethink our approach. Knowing the court system as we do, we wanted to determine how to be the most effective for our members in the least amount of time. After our review of the key member facts and the case law, we found a common thread that was running amongst all of our members. And we decided to pull the injunction portion of our existing lawsuit forward. And when I say pull it forward, based upon case law and Minnesota state statutes, which Eric will speak to shortly, we filed a summary judgment for a permanent injunction closing down Minnesota Child Protection Services until the unconstitutional statutes are fixed. And so Eric will explain all that to you in detail legally. The goal of our organization is the preservation of the family. This means we are actively pursuing, preventing, and undoing these illegal kidnapping as soon as we hear about them. This includes, but is not limited to, overturning court orders where parents have had their parental rights terminated based upon fabricated evidence, misleading court information, or withholding exculpatory information from the court. We are also seeking jury trials for all termination of parental rights proceedings. My ultimate long-term goal after we finish in Minnesota is to perhaps go state to state, starting with the worst, reviewing their state statutes, seeking federal injunctions for the preservation of the families due to unconstitutional or non-compliance with federal mandates for the reunification of families once CPS has gotten involved. This doesn't mean that child protection services are not needed and that children do not need to be protected. All social workers are not bad. I have been in contact and met with several current and former social workers, mostly young, who have confirmed that they have been advised that they are being forced to remove children, from the household based upon their supervisors. I spoke to a former CPS supervisor last week who informed me that she resigned because she did not agree with the current system or what was happening, and that it needs an overhaul from the top down, starting with the most senior people needing to be removed. My research with parents, some of them are here from our organization, who get off work, has led me to uncover that there are things happening in CPS, not just to myself. So what I thought, when I thought my case was egregious, once I started talking to the other members of our association, I started finding out they were having the same issues. So I sent out a questionnaire. And so when I got back the questionnaire, each petition by the social worker contained fabricated evidence, misleading information, or withheld evidence from the court. This is because the person who is responsible for the social worker is also responsible for terminating your parental rights. There's a serious conflict just in that function, that job function itself. How can you say, I'm going to reunify the family and terminate parental rights at the same time? So children are being removed without court orders or emergency situations. Parents are not being provided with a written safety plan to prevent the removal of the home, from the home. Parents are not being provided with a written reunification plan that tells parents exactly what needs to be done in order for the child to return home. Parents were not provided with written out-of-home placement plans that were signed within 30 days as specified by the law. And so there were a number of allegations that went on. And so once we spoke to the members, we took down declarations, we collected over 46, where everyone had the exact same thing happen to them that happened to me. This information was submitted to the federal court, and Eric will speak more to that later also. One of the reasons, it's interesting because people keep asking me, well, why is this happening? We don't understand, CPS is supposed to be there to help children. And I advise them, based upon my research, what I've learned is that there are many ways to obtain federal funding for the programs. Title 4E, the Social Security Act, is by far the largest. Title 4E accounts for 50% of the federal funding available to states. To be eligible for Title 4E foster care program, the vehicle for which the states must use to get this money, and this is the largest percent of the budget, is the child must be in out-of-home placement. They have to have been removed or considered needy. They have entered care through a judicial determination, and they have to be in a licensed foster care facility. So you don't have to believe me, look this up, So this is just one of the federal funds that's available to Minnesota. Now here's the kicker that I learned during my research. The state government retains 25% of all federal funding for administrative fees before reimbursing the county and local agencies for the actual costs incurred for the services. So when I looked at the budget last year, DHS had a budget of $16 billion. $10 billion came from the federal government. Out of that $10 billion, 25% is kept for administrative fees. I don't know, but people were asking me why. That's what I've uncovered thus far, and I'm still digging. There's I've started calling it a CPS playbook also as to why children are being taken. While everyone here is a victim, we all are, I'm going to demonstrate, what happened to me 4 years ago, and it's still happening statewide as recently as this past week. Since we've started the organization, we've been able to help people pro se get their children back. Mara here had her children taken. She was a victim of domestic abuse. They took her 3 children. We provided her with information on what needed to be presented to the court, and we were successful in assisting Mara in getting her children back. So just last week, we were contacted by Amanda. And what's really interesting with Amanda's case, and you can look at the court file, I'm going to give you the case number as soon as I finish. When Amanda contacted me, I advised Amanda. I said, social worker Katie Cannell, because that was her name, I said, she will lie to present her case to the court. I said, the social worker will file a petition to try and take all 3 of your children into foster care immediately, and not just the child that she was investigating. I said, before you go to your first court hearing, prepare a declaration of facts from your side of what happened in the case with any documented evidence that you have. I said, before you go to the first court hearing, prepare a general opposition to the petition being filed and tell the court why you are a fit parent and able to raise your child. After the first court hearing, I said, prepare another declaration of facts based upon what happened in the petition that you received. And I said, after the first court hearing, prepare a response in opposition to the petition that was filed. Make sure you point out what you oppose specifically. Make sure you point out any misrepresentations or misleading information, and tell the court why you are a fit parent again to raise your child and why your children should not be removed from your household. Sure enough, last Wednesday, May 29th, social worker Katie Cannell filed petition number 49JV18786. And she did exactly as I predicted. She requested the county take away all of Amanda's children based upon fabricated information that she knew was not true, because she had requested a full examination of her son prior to going in court and filing that petition. So she knew there was nothing wrong with Amanda's son, although she was claiming medical neglect. She failed to provide this critical piece of information to the court, St. Cloud Hospital's examination. Instead, she submitted to the court the allegations that something was wrong with Amanda's son. She took the son to the hospital, had him examined, found out there was nothing wrong, but still submitted the allegations and said, I want to take away all 3 of your children. So don't believe me. I will forward you all of the court documents. Just give me your information, I'll send it to you. So what was really happening was, so when she got to court, the court was shocked at how prepared Amanda was. They weren't used to this. So the judge did not remove all 3 of her children. The judge allowed her to keep the 2 while the judge investigated what was going on. To be safe, she said, all right, I'm going to postpone this for a week. Let me look at what's going on here. So Amanda subsequently filed her opposition to the petition, and she pointed out paragraph by paragraph where the social worker fabricated evidence. Now, I am not going to, be the judge. I looked at it, and in my humble opinion, it was all fabricated. So I'm going to send you the filed document that Amanda submitted to the court, along with the declaration of facts, and you will have evidence firsthand of what happened to Amanda just last week. Same thing happened to me 4 years ago, and it's happening to all of these parents. So, this is something that we feel needs to be stopped. This is why we are pulling the injunction forward, and we are asking the court for a permanent injunction to stop these activities. I'm going to turn it over to Eric now so that he can speak about the legalities as it relates to the petition we're filing.
Yes, thank you. Again, I'm following in Dwight Mitchell, and it's a tough job. He's a very good speaker, and he's a very good client, but he's a very aggressive client. And I'm sort of shocked at how far he's gotten with this idea that it happened to me, my children were taken away without a proper foundation in law, and I'm going to start an association to do that. And so these people have been attracted by Dwight's leadership and Dwight's cause, and this is a victims group. I mean, it should shock everyone here and everyone watching. This is a victims group. I mean, this is no different than Jeff Anderson's group when Jeff Anderson sued the Catholic Church over child abuse. It's just here, we're not representing 600 victims of sexual abuse. We're representing thousands of Minnesota children who have been separated from their parents unjustly. When we started the first time, about a couple months ago, I was really focused on Dwight's facts. But as Dwight introduced me to this victims group, my eyes started open to see what a broad systematic problem we have in Minnesota. And so the problem is, first, the commissioner of the Department of Human Services is in charge of everything. The commissioner, of course, advises the legislature on how to reform statutes and so forth. And so when we look at the statutes, we have all these problems. And these problems have been recognized by the U.S. Court of Appeals for the Eighth Circuit. And the problem basically is that these statutes have not been drafted in a careful way that when the government takes the child from the parent, that the government has to show a substantial level of harm being prevented. So can you believe that? So I started off with the spanking thing with Dwight. Dwight's child was taken for 22 months. 2 of them were taken for 5 months because of an ordinary spanking. And then all of a sudden we're finding out all these other cases, a lot of them based on neglect. But the central problem and where everything comes together is Minnesota statutes do not require the government to show in court that there's some harm being prevented when the child is taken away from the parent. So what are we left with? We're left with statutes regulating parental conduct. I mean, basically manners. I mean, a lot of these parents here are victims because the social worker said, you're being uncooperative. Well, since when does being uncooperative with a government official mean you lose your kids? And this is all kind of exponentially important because we have single parent families now. So the consequence of having the statutes drafted badly and the commissioner not administering them according to the Constitution and the courts not keeping an eagle eye out for abuses is that we're having all these separations that are unnecessary. In Dwight's case, the psychologist said, Dwight, the kids aren't getting counseling because of what you did. They're getting counseling because they're separated from you. And none of the government thinks that's ironic. Because, when you think about, we have great sympathy for the victims of sexual abuse in Jeff Anderson's case, but these kids are separated from their parents, in Dwight's case, for 22 months, no contact. That's bad. I mean, they're both horrific. And you can talk to these victims here, and they can talk about the experiences their children have had, the ones that have been returned or have had a chance to visit. So what has changed with the litigation strategy is we actually started with Dwight just saying, I want justice. And then he started the association. The association has succeeded beyond his wildest dreams as a victims association. So I'm not Jeff Anderson, but Dwight Mitchell is acting as Jeff Anderson. Jeff Anderson collected clients, victims of sexual abuse, and he came forward and said, we got to clean this up. Now, it was different in a way because there's a big pot of money at the end. And of course, the establishment, the county attorneys, were on Anderson's side. Dwight doesn't have a big pot of money for all these people. All he can do is get an injunction to fix it. He can stop Child Protection Services from operating under the unconstitutional statutes. It would be a statewide injunction, and that'll help a great deal. The other thing is the county attorneys, they're on the other side on this one, right? So in the Jeff Anderson deal, Ramsey County Attorney Choi sued the Catholic Church. We're not going to have any county attorneys come out on our side. No way. The county attorneys are charging these people for neglect, malicious punishment, whatever. The county attorneys are involved in advising on the civil side. So the county attorneys are part of the establishment in this one. But what we do have is a federal court, and we have U.S. Court of Appeals decisions, in the case in Iowa, the Allsager case, finding that Iowa's child protection statutes were very similar to the ones in Minnesota, were struck down. So today we're communicating with the judge and lining up to have a summary judgment motion hearing on an injunction. And the big point here is that we're going to be sending our communications to the judge later today, and that Dwight is announcing that he has a victims group. And at our first press conference, we didn't have that. And we're going to continue to meet with the press and continue to have press conferences as we have more victims. Why? Because the media should know when this is happening. This is our government, and the government is taking children away from parents on extraordinarily meager facts. I mean, this case here with the medical neglect, which we'll talk about, it involved simply taking a child out of a hospital against medical advice. Now, is that medical neglect? Well, the statute says you can terminate parental rights permanently because of medical neglect, but it doesn't define what medical neglect is. Medical neglect, to justify separating a child from a parent, you'd have to show that you're preventing some harm to the child. Is it medical neglect to go get a second opinion or a third opinion? Also, the statutes, as we've discussed before, don't have a good definition of neglect generally. One part of the statute says you got to give required care to your child. The next section says you got to give special care to your child if they need it. Well, what's required care? What's special care? These are not carefully drafted to meet the requirement that when the government permanently terminates parental rights, that it's preventing some harm to the child. And all of these people here are victims, and they have to be taken seriously. And it's not that we can just shove them aside. I mean, maybe that was acceptable before all these lawsuits against the Catholic Church, but now it's not. These are victims, just like those other children were victims, and we didn't make sure that we protect children, even if it's protecting children from our government.
Can you pronounce your last name?
Eric Cardall, Kaardal.
And could you explain here exactly what you're asking the government, the judge to do, and what you have thus far filed, and in layman's terms as much as possible?
Yes, initially we filed a complaint that was focused on Dwight's claims, and now it's changed. Now the focus is turned on Stop Child Protection Service from Legal Kidnapping and Association, and the association is of victims. And Dwight collected about 50 declarations, 47 declarations on behalf of these victims, and he's submitting them in the case. And like I said, there's no big damages award at the end for everybody. It's not like that, because we're suing the government, and the government has immunities from that kind of a claim, but we're seeking an injunction. So Jeff Anderson would say, well, we're going to stop the Catholic Church from abusing because we'll get big damages. That's exactly correct. He did. He won. Congratulations. In our case, we need to get an injunction to stop the government statewide so everyone's protected. So that's one difference. With respect to the counts, there are 6 facial counts. Counts 1 through 6 are facial claims. And so in the amended complaint we filed yesterday, the 6 amended claims are all focused on the statutes are facially defective, either void for vagueness, violate the Equal Protection Clause, violate the Due Process Clause either substantively or procedurally, and they don't have a rational basis. And so those 6 counts are being presented in the summary judgment motion. We'll start the process today by writing the judge a letter. And the complaint that we filed yesterday sets that up. So this is the complaint that converted this into basically what might be called a collective action, and not a class action, because that'd be for money. This is a collective action, and we're seeking an injunction for the benefit of everybody. And so specifically, the statutes that we're concerned about are 260C.007, which is the definition of child in need of protection or services. That's a euphemism for we're setting up to take your parental rights away. And in that statute, it's not clear whether a parent can touch a child or not. They include such definitions as 5th degree assault, which is an unwanted touching, as possibly child abuse. So as most parents know, eventually you're going to touch your child in some way, and sometimes to grab them out of a street in harm's way or whatever. And so we're complaining about that statute, the incorporation of malicious punishment, the medical neglect definition I mentioned, the distinction between care and special care. And then when you add it all up, no one would know how to parent based on this definition of CHIPS. It's very clear that it doesn't give sufficient advice. Then with respect to termination of parental rights, that'd be 260C.301, they even have this doozy. To terminate parental rights, one of the reasons you can permanently terminate parental rights is that the conditions that led to the out-of-home placement haven't been adequately addressed. So think about that. that you're terminating parental rights, and you can't even be more clear that in order to terminate parental rights, you have to show a connection that you're preventing harm to the child. And that's what the U.S. Court of Appeals for the Eighth Circuit has said. And this is all these statutory provisions are cited here. Then with respect to another example, procedurally, there's no requirement, and this is what they're kind of talking about, there's no requirement for child protection workers to provide exculpatory information in the proceeding. So when we work with prosecutors, the prosecutors are under threat of civil lawsuit if they withhold exculpatory information. Now, child protection workers, they're in this dual role. It's even sneakier because they're in the role of being your friend, we can return your children, and also prosecuting you to terminate your parental rights. They're not required to share with the court or share with the parent exculpatory information about the parent's conduct. And so that's where you have the social worker last week, after we filed the lawsuit, the social worker last week filing a false report and being caught because she didn't disclose the hospital records she had gotten. Similar to Dwight's case. Remember, Dwight's case is based on, I beat my ex-wife's description of my parenting down in 3 proceedings in New Jersey. Dakota County had the marital dissolution order, had the conviction of his ex-wife for trying to kidnap the kids after he had won the marital dissolution matter, and had the police records. And Dakota County did not disclose the New Jersey records, even though they had possession of them, to the Dakota County District Court in the proceedings. And Dwight protested that, but to no avail. And so the point is, they don't provide exculpatory information because they don't have to. Another procedural problem is once your children are taken, you don't have any leverage. Because one of the things is the parents do not get, cannot challenge the inadequacy of reunification efforts until the very end, basically the termination of parental rights hearing.
Can you clarify, have you filed the motion for a summary judgment for a permanent injunction? Have you filed it yet?
We're going to be filing the paper today.
What time are you going to file?
This afternoon, we're going to file the request for filing a summary judgment motion.
Okay.
Yep.
Related to that, are you asking that all county agencies stop all child removals? Is that what you're asking?
We're going to be asking that that they can't operate under the unconstitutional statutes.
All of them, or
Just the ones that I've identified. I can go through them on the page if you want.
Okay.
So they can still remove children?
The ones that are problematic are listed on page 95. 260C.007, subdivision 5, subdivision 6.2, 1 through 3, 4, 5, subdivision 13, 260C.301, subdivision 1, B2, 4, and 5, and 626.556, subdivision 2, F and K. And there might be a couple others, but they may be able to operate around those because the other ones aren't problematic. For example, the one I brought up was that I think it's fine for the state to have a CHIPS definition that says you have to provide the required care, but once it says in the next line you have to provide special care, then the parents are left, well, what's the difference between required care and special care? And neither of them really get to the point of what harm are you preventing to the child? There really needs to be, as in the Iowa case, a definition that you can't terminate parental rights unless you're preventing harm to the child. You can't be regulating parental conduct. Like the disorderly conduct statute, we all think of it as, well, yeah, someone's disorderly, but you can't regulate manners. So here we got into this business of regulating parental conduct, not protecting children. And that's the complaint of these parents. And to some extent, I think I'm a distraction because even my work has been overwhelmed by the stories of the victims. I'm just being honest, right? That we were set, and then more victims came in, more victims, and that's, I mean, that's just, so I'm trying to collect these stories, and so we have 50 declarations, but the declarations we need to go back and get more detail and build the case up more. We're going to go ahead with the facial challenges because we don't need declarations for that, and we're going.
Just for clarification, just so we understand it, that you just listed what you consider the unconstitutional practices. Those are the things you want fixed, right? But the permanent injunction is against Dakota County to stop all CPS.
Well, against the state commissioner.
It is against the entire state.
Yeah, because under the statutes, the commissioner implements the child protection programs, monitors them, supervises them.
Okay.
So we can require.
And what happens to what you already filed previously? Is that still in place?
This is just a replacement, right?
Oh,
Yeah.
it's a replacement, so
Yeah, it's a
the other
replacement.
thing does go away, or it doesn't go?
No, it's the same case number.
We just added, I guess what she's asking is, no, the goal is, we had the injunction in the original lawsuit. What we did is we're asking the judge now to bring the injunction forward based upon the unconstitutional practices. So when he says a replacement, it's called an amended complaint. And all we did is just amended the complaint to include the group, the declaration, because, we got the 46 declarations, so we're adding that to the case, and we're saying, Your Honor, we want you to hear this injunction part now, not at the end, because based upon state statutes, we can present this facial claim now. And so if the injunction is granted, as it's been asked, they are not allowed to act under these statutes. So in effect, it's going to terminate the services they're doing, especially since we're going after their complete definition of CHIPS. And so if that definition for taking the children is not correct or unconstitutional or vague, well, you can't take children. Now, are they going to still be emergency situations? Of course, they're going to take children out of emergency situations. I'm sure the legislature is going to have some emergency hearing and try and fix this as quickly as possible because they don't want to leave children in danger. So, but we're essentially saying, we're asking the federal court to stop this.
And is this something that would happen immediately will the judge consider this immediately now?
That's what we're asking her to do. So that,
I can address that.
Sure.
What we're doing is we're asking the judge to do the summary judgment motion first. And so we're sending a letter to the judge saying we want that to be the first thing in the case. And so we hope that happens in a month or two. And then the judge will decide. We could have brought a temporary injunction motion or a temporary restraining order, but that's really not what's happening. What's happening here is my office and Dwight's organization have been overwhelmed by the number of victims coming forward, and we're collecting the information. And we wanted to inform the press. Even Amanda's case last week has created challenges for us because we want to incorporate her facts. So we're catching up, but the judge has said that we'll send a letter, request the process for doing the summary judgment motion immediately. Then we'll file the supporting declarations and affidavits, and we think we'll win. But the reason we're going to win is not because what I'm doing. It's because the victims have come forward and they're actually organizing. And why I wanted to compare this to the Jeff Anderson case is that I think to some extent when Jeff got started in that, I've met him, that he was kind of overwhelmed by these people coming in, and that's what happened. And so Dwight's organization has taken a big step forward in that it's become an organization of dozens and dozens of victims, and is going to facilitate the storytelling from these victims. And I think you'll be astonished at the fact, just the meager facts that the child protection operates on and how they operate in court and how they take children away on things that really don't justify having children taken. So I want to turn to the victims as soon as we can. But Dwight,
Can we hear from one of the victims? Or?
sure, Amanda, would you like to speak quickly? Amanda has to go to court, so she can't spend all day. She has to go to court this afternoon, so I'll just let her talk briefly. If you want to ask her a question.
Can you just explain your situation, how kind of it began, how you ended up in court and your situation?
Well, less than 2 weeks ago, I took my son into the hospital, Children's Hospital, for a cough and cold symptoms. As a precaution, we stayed overnight for observation. The next morning, I had waited long periods of time for the doctor to come up and basically say that he was fine to go and he was fine to be discharged. They had already done the discharge physical, which is in the paperwork, and I was, after waiting, I had asked to leave because I wanted to put my kids to bed, and I had my 3-year-old with me, and I asked if there was anything else that needed to be done. They said no, that there was no other testings or anything that needed to be done. And so, but they said the only way that I could leave is if I signed a form. And so I signed that form, and then I left. To keep a long story short, I left, and a couple days later, the police showed up at my door saying that they had exigent circumstances to remove my son from my care. And an officer stated that I had withheld life-saving medications from my son, which is not true. And my declaration of facts has all the medical records to back that up and prove that. And so they said they were taking me to the hospital because he was in such an emergency situation. Instead, they took me to a clinic with a primary care provider that I had was trying to switch to another primary care provider. She checked him out. All his vitals were stable. They already had a foster parent in the room to remove my son before they ever proved that there was actually an emergency situation. And so even after I proved them wrong, they still took my son. And so, now I had my first hearing. They requested all 3 of my children. They did not get all 3 of my children. And I think, as Dwight had stated, that I think as a precaution, the judge kept my son Xavion in care, and my oldest 2 children stayed in my care. And so, I didn't get to present all my facts in court to prove that I should have my son returned to me, and to prove that the 72-hour emergency hold on my son was not needed. And so I have court this afternoon, and I'm hopeful that I will get my son back today. I have indisputable facts and evidence. I have the declaration of facts, the opposition to the petition. I have all my facts lined up. And so, yeah, I guess I hope to get him back today.
Was there ever anything wrong with your son?
No, there was nothing wrong with my son. There was, from what an officer said to what the social worker said, there's a bunch of fabricated evidence saying that my son had stopped breathing, or that my son had had trouble. The social worker, Katie, she had stated that my son had had trouble breathing for 3 days, and that's why I brought him into the hospital. When on the medical documents it states the chief concern upon arrival to the ER was coughing.
But this is something indicative to the system. It happened to me 4 years ago, and the reason I had Amanda speak is because I wanted everyone to see that it's still happening today, and it's happened to most of us. A lot of people, they don't believe. They were like, oh, it couldn't have happened. I'm like, look at my complaint. There's 85 pages of documents. Look at her court case. I just gave you the court number. All of her documents have been submitted to the court. You can read it firsthand. I will send it to you. You will see what the social workers are doing. And it's happening disproportionately to, minorities and Native Americans even more. So it's happening to everyone. It's happening to all ethnic groups.
How old is your son?
My son, he was 10 months when he's taken. He's 11 months now.
And he's been gone for a week?
And he's been gone for over a week.
Do you know where he is?
I don't know where he is. I somewhat met the foster mom, but I try to get updates on my son. I did get one visit with my son. They denied me maybe 3 times my court-ordered visits with my son. They denied me, and then when I went in there and I told them that if they kept denying me, I was going to bring it to court, they suddenly immediately, a couple hours later, gave me a visit with my son.
Why do you think they're doing this? I think this is what blows my mind, is what's the reasoning behind it? Are you saying it's the financial benefit of taking the kids, or what reason?
From my forensics, and so, it's kind of interesting. What my job is, I'm a management consultant, so my job is to actually go into organizations and actually determine what's wrong and make them more efficient. So my job includes forensics. So I go into my company like Mobil, Shell, Exxon, and I'll go in and I'll look at everything. So I just applied my job skills, what I do for a living every day. And while I can't state it for a fact, the evidence sure looks like it's monetary to me. When I look at how they receive their federal funding, when I look at the fact that the state keeps 25%, so the counties will bill, and then the state, the federal government will pay the state, and the state says, I'm taking a 25% VIG off the top, and I'm giving you the money back, county, for the rest, for the services you bill back. What else can it be? To say that's exactly the reason, I'd have to have someone admit that. I'd have to have a social worker come forward. I do have documentation from the Assistant Director Koppel where he actually tells his social workers to bill the federal government. And he actually says, we'll get more money, more funding, more positions. I can forward that to you. I just have, everything is kind of interesting. Because Minnesota is a public access state, I have downloaded over 1,000 files in doing my forensics. I've downloaded all the accounting information. I even have the minutes from their last 2 accounting sessions where they talk about the money, the budget, how they're doing, the comparisons. So if anyone is really interested, I'm sat here and I'm categorizing it. And so I'm doing a chronology, and I'm saying from the time the child is taken in, here's how the process works, and here's how the money comes through. So as I spoke earlier, as it relates to the Title IV-E, they can't even start collecting the money until the child is taken out of the home, put into foster care. Then they can start billing a minimum of 1 social worker a month and 1 supervisor a month per child the minute they get that removal. So the very first day that child hits foster care, they can start billing. So they have a 72-hour hold. And in Amanda's case, they should have given the child back, especially when the supervisor did all of her investigation and got the report that she requested from the hospital that said, hospital's fine, no, he's not supposed to be on an apnea monitor, no, he's not supposed to be taking any medication, nope, she's been following up.
Well, who alerted CPS?
Her primary doctor, meaning what ended up happening is that the hospital called the primary doctor, wanting to know, was everything okay with the son? The man had left. And so the primary doctor, because she's a mandatory reporter, she had to call CPS. Now, she called CPS because Amanda signed an AMA. But an AMA is not grounds. An AMA is against medical advice. But that's not grounds for removal. There has to be serious danger.
You left before they wanted you to leave because you didn't sign papers, or what? Is that what happened?
I left because I was waiting on a doctor for hours and hours, and I was told my son was fine and ready to be discharged. I just needed a doctor to come up there and say it. And so I was made to believe that everything was fine, and I double-checked to see if anything else needed to be done. Nothing else needed to be done, so I thought I was okay to go by signing this form.
Forgive me for asking, have there ever been any CPS issues in the past that they would, maybe be more focused on you for any reason?
Was actually, the social worker I'm dealing with now, Katie, she was actually the one who showed up at my door when a friend that I had a disagreement with decided to retaliate against me and call CPS and make allegations. But I did not let this social worker, Katie, into my house. I told her she wasn't coming into my house without a warrant. It was false allegations that my children were safe, and that's all she needed to know. If she had any further questions, I would have to obtain a lawyer in order to answer those. And so she tried to, I got a letter in the mail saying that she was going to talk to the county attorney and see what she could do because I hadn't met with her.
And the county attorney closed the case.
Yeah, the county attorney closed
So
the case.
there was nothing there.
So really, no, I have no past involvement, but clearly I've dealt with this social worker 2 times and she's retaliating against me, and that's why I believe, in my opinion, that this is going on the way it is.
One of the things that people aren't aware of, and I wasn't even aware of it until I started looking into this, is that from a federal funding perspective, you asked me the question before, why? For Native Americans, the federal government allows social service to bill back 100% of all costs associated with a Native American. So that means social workers, judges, clerks, anything related to the system. For African Americans, it's 50%. So 50% right off the top comes back. So when you look at the disparate treatment, and you say, well, why are there so many Native Americans, which are the highest, and African Americans? Well, you're like, well, right off the bat, if you can charge the federal government for the social worker, the supervisor, the judge, the clerk, and it's all in the Title IV, just read it. When I looked at it, I was like, no wonder. And like, now I know why they're taking all of these people. One, most of them are poor and can't fight back. And two, the government funding is so obvious when you can bill the federal government 100% of all costs for a Native American and 50% of all costs for an African American, right off the top. With the other races, you can still bill. It's not that you can't still bill, but you just have to do a little bit more due diligence in order to get the federal funding.
It seems like you're saying this is systematic.
It is systematic. It's happening 23 counties. So we have declarations. Out of the 250 members, I wanted to show that it was happening universally across the state. So I went through, and so I have declarations from 23 different counties, as far north as Little Falls, down to Rochester, north, south, east, and west, just to show the federal court that we do have a systemic problem. And so out of our 1,200 members, I said I need one from each county who's having the same issue, just to show the court that we have a serious problem. Are there any more questions?
Amanda, if I may ask a question, what do you want out of this situation? What do you want as a parent?
Well, my top priority is to get my son back, but coming to find Dwight's association or organization, I realize it's a much bigger problem. And I will get my son back, but it doesn't stop there. I feel like I need to do more, and I need to share my story. And if I have to share it 100 times, 1,000 times, I will.
Please feel free to talk to any of the victims here. Everyone here is a victim. If you have any questions, please feel free to ask us. If you want the information that from Amanda's case, just let me have your email address and I'll send it to you right away. I have my computer with me.